Do get in touch, 80295. Let's talk to Patrick McGuire of Thompsons Solicitors, because, Patrick, I'm guessing that one thing that's going to happen here is, quite rightly, the people who've been abused will think, I have been let down by a system, and they'll want some kind of redress. In a Scottish context, where are we with this?
Thank you, John. Yeah, you're absolutely right. And just as your former contributor said, I would encourage everyone to come forward. First and foremost, we need to shine a light on that. People who do wish to explore the possibility of seeking redress for the wrongs that they've been subjected to, currently, as the law stands, will face an uphill struggle. The law in relation to time bar, as it's called in Scotland, is utterly out of touch with what anyone in society would think to be the correct way of looking at matters.
Why?
Thankfully, it's soon to change. At the moment, the law is such that, in effect, a victim of historical abuse will have had 3 years from turning 18 within which to seek justice by raising a court action. And while in the law there is the opportunity for the courts to exercise what the legislation describes as discretion and to extend that period, there have been several test cases in Scotland, test cases that my own firm has ran, because we utterly oppose that concept. But the courts have dug their heels in, and the law is now absolutely set that the discretion is a chocolate fireguard. It is no use whatsoever. That actually stands in stark contrast to the position in England and Wales, and we'll have seen many reports in the past few months where victims have been successful in seeking and obtaining justice by means of compensation.
I don't want to jump in, but at the moment the rule is beyond 21 you can't sue, is that right?
In a nutshell, that's absolutely correct. As the law currently stands,
but it's going to change.
That's correct. The Scottish Government has announced that there will be a law taken forward, the Limitation Child Abuse Scotland Bill. It was atop their legislative programme this year, and what that will do is it will remove completely the time bar provisions in relation to victims of historical abuse, that there will be no time bar limit whatsoever. And the bill is framed in a way that the term abuse is actually very wide. It covers sexual abuse, it covers emotional abuse, it covers physical abuse, and it actually covers neglect. So this bill, when it's taken forward, subject to one thing that will raise about how far back it goes, will make an incredible difference to people's lives. And so today, as we reflect on everyone who's coming forward, and we encourage them to do that, a clear message must be sent to the Scottish Government that they cannot delay in this piece of legislation, that every day that is wasted, justice is denied to victims, that they have to move with all due haste now to get this act on the statute book.
So Patrick, would this be criminal proceedings then, or we're talking civil proceedings? Is that easier to bring to court in a sense?
We are talking only the civil court system seeking compensation for the wrongs that have been suffered.
Is that the only way people feel they can seek redress then?
The police have had various investigations, and no doubt that will continue. That in many ways is out with the victim's hands. We are in the hands of the police and the Procurator Fiscal Service to see if they can build a case. And as you've identified, the standard and level of proof required for a criminal conviction is significantly higher. And so in terms of power being placed into the hands of the victims, and in many ways that is of course what we're talking about here. We're talking about empowering victims of abuse to stand up to their former abuser, that this legislation will allow them to do that through the civil courts by seeking compensation.
And Patrick, briefly, John Swinney's public inquiry has been set up, but it wouldn't cover, it's not going to cover, is it, the likes of football and other sports? And some charities, I'm told, are not happy. Is that true?
That's correct. The public inquiry will cover only in-care abuse, and it will be cast no wider than that. It's been an issue of significant controversy, and many of the excellent survivors' charities out there have expressed significant disquiet about it. I personally think it should be wider. I suspect that it's to do with a cost. There may be other issues too in relation to the fact that... sorry. Yeah.
No, just briefly before we go, we're running out of time. Who would be sued?
That would of course vary from instance to instance. It could be the abuser themselves, but it's more likely to be the organisation for which the abuser worked, whether that's a football club, whether it's a local authority, whether it's an organisation such as the Scouts, that's not employment, but they would still be responsible, whether it's certain religious organisations, that these organisations will all potentially be required to pay compensation and to afford the victims the justice they deserve.
Patrick, thank you for your time. Patrick McGuire of Thompsons Solicitors.